You know, it seems like ages ago, I did a series of lectures comparing Napoleonic civil law with that of the United States or English common law. I had to review some of the notes there because lately there's been a movement about police reform and judicial reform, sentencing reform, and things like that. All of a sudden, the press and the people are starting to become aware of some of the discrepancies and some of the, I would guess you would say, the fallacies or foibles or failures of our legal system. And that's because we don't have the same legal system that we are told we have. About the time of the Nixon administration, we changed from a Napoleonic or from a common law system to a Napoleonic system without too many people realizing or recognizing the differences. So now we've got all kinds of protests, all kinds of agitation, all kinds of requests for change of the justice system, etc. Well, it's not a justice system anymore, it's a legal system. That's the first thing to point out. Secondly, you have people talking about a pendulum between conservative and liberal or whatever, and it goes back and forth. Well, what most people don't realize is that in about 1870, they put the pendulum on a different clock. So you can't say it's swinging right and left or this way or that way. And that justice is sort of a grand medium or golden mean or whatever the hell you want to call it. So until we can get to a fair system, we're not going to get much reform, because currently under the Napoleonic system we're operating under, we the people are the enemy, and the police is an occupying force. And that's because that system came from Rome, and the Romans went out and conquered all over the place. Gaul, they conquered Goths, Visigoths, etc. And they really didn't care too much about the indigenous rules or ruling of the conquered lands. They did care about taxes and slaves. And as long as they got their quotas of taxes and slaves, they didn't particularly give a shit about how the territories were governed. But that kind of got a little rough when they got into the Germanic areas where the Goths were, and the Huns, people like that. It was a lot different system. And that was sort of the group that founded the Anglo-Saxon system. The Anglo-Saxon system was merged with a few other little tribal nuances into the common law, which became the common law of England. And the common law of England was kind of set forth in a Saxon publication called the Saxon Spiel. Now, when we get to about the 1600s, about the time that, right after the time of Columbus, and there was a look at the so-called New World, things started changing. And if you recall your history, right about that time, there was a lot of change in the religious views and the religious practices of Europe, with the invention of the printing press and more copies of the Bible being available to read, and various groups dissenting from the main church. You had a bunch of debate going on, a lot of dissension, and a lot of controversy. So, for instance, you had one king on the continent of Europe decided he wanted to rip off the church. So the church's bank at that time was the Templars. What he did is he locked up all the Templars he could get his hands on, executed the Grand Master, and ripped them off for their golden treasury. Well, Henry VIII in England wasn't going to be outdone by Philip the Fair, so he decided to go one better, and he ripped off the whole church. You can go to Canterbury, for instance, which is the head of the Church of England, and see most of the icons and relics clear from the Roman Catholic Church days. So the difference after the Henry VIII rule was the fact that the king or the crown was the head of the church, as well as the head of the secular government of the country. Then you had a guy named Oliver Cromwell come along, and you had a revolution going on in England. People taking it a step further and saying, why should we have the king as the head of the church? Why the hell do we even have to have a church as such? And just the same as the Roman Catholic Church, with just a new head, let's reform the whole church system. So the Reformation started. You had a little problem in England with the revolution, and there was lots of debate about what religion was good, what religion was bad, what religion should be established. And the church founded by Henry VIII was called the Establishment Church. So you had disestablishmentism, anti-disestablishmentism, all kinds of variations going on. Some sects sent to Holland and some sent other places. And right about that time, you had various companies that wanted to band together and go to the New World. One such company was Plymouth Company. And they wanted to export their whole colony and get on some ships, leave England, leave the hassles, leave the Roundheads, leave the Blackheads, and all these other people, and just get away from it all. Well, one of the people who tried to start a different religion was a guy named William Penn. And William Penn was tried essentially for preaching his religion, which was outlawed by the king. So he had a jury trial. And the jury refused to convict him of the charge of practicing an illegal religion, essentially. So the judge in the court there told the jurors to go back and deliberate and come back with the decision that the judge wanted. The jury failed to do it, and so the judge jailed the jurors. Now we'll look here and see what happens. What happened is they finally overturned and let the jurors out, and that was the start of a new procedure that seriously encroached on the prerogative of the king. And the feeling was there the king shouldn't have ultimate power over everything, and his laws shouldn't be obeyed without question because he wasn't a dictator anymore. They had the Magna Carta and sort of a Bill of Rights and things like this. So this is one of the big changes that happened right before the United States or the colonies in this country were formed, and people came here in order to essentially not be subjected to the arbitrary, capricious, mad ravings of any despotic ruler. It was interesting because in that case, um, it was said that it was not for the jury to figure out if a defendant is guilty of breaking a law, but rather determine whether the law itself is just and fair. And the reason for the law being in that state is to protect the people from government oppression, overreach, and natural corruption. And that's the primary role of the jury. Once you decide if the law is fair, then you can decide whether or not the person broke the law. So this has been our historical basis of law ever since Magna Carta. Law is not just the law or decree, but common law that was adopted in this country prior to the Revolutionary War, prior to the Revolution, prior to the drafting of the Constitution, etc. So it was the right of a jury to rule on the logic of the law, the fairness of the law, and to keep the lawmakers and executives in check. Because it was known in England that a lot of the kings weren't righteous and just, and they were despotic. So when the colonies founded their constitutions or charters, as they call them, you had things set up in such a way that they did check and see what their function was in the Constitution. So Maryland, for instance, well, actually, original colonies had jury nullification written into it, into their charters. So the Constitution of Georgia, the Constitution of Pennsylvania, which was founded by William Penn, and some other colonies had the idea of what they called jury nullification. And one of the commentators at that time in 1790 said the jury shall be the judge of the law as well as the fact. And that was what the Pennsylvania Supreme Court said. U.S. Supreme Court with John Jay in 1789 said the jury has the right to judge both the law as well as the fact in controversy. That was said by a guy named Samuel Chase, who was a famous justice. And it was also said by Oliver Wendell Holmes, Harlan Stone, and a few other justices. So, law under common law wasn't just rules. It wasn't just law. It was a social structure. It was a social organization. And it was affected by mores, folkways, norms, etc. And it was very specifically granted to the people since the hard fought after Magna Carta for various reasons. So, for instance, in 1972, the U.S. Supreme Court said, the pages of history shine on instances of the jury's exercise a prerogative to disregard instructions of the jury. Now, what we've seen since then is a whole different view of things under the Nixon administration. We get judges that, in their ignorance, claim that a jury's function is to judge the facts of a case, and the judge is to apply the law. Now, think about the logic of this. Where do judges come from? They don't come from the carpenters and the ditch diggers, the beauticians, the barbers, people like that. They don't come from teachers. They come pretty much from privileged class. And even if it's not conscious, they're going to represent their class interests and protect their class interests. But because of various social upheavals and norms and reasons and economic reasons, and the fear of the rich losing some of their money and power to the poor, they came up with the idea that we don't want the poor judging our rules. We want them to blindly obey. So the judges decided that they would overturn centuries of precedent and come up with rules that juries can't judge the law. They can't judge the fairness. That's the judge's job. Well, immediately that puts a cultural and a class bias into the rulings. Now, that gets misrepresented by the ruling elite of this country as being a racial bias. So what do they say? We need more black, we need more women and things like that. The problem is, as long as these people come from the same socioeconomic class, there's not going to be much change because the ruling people fear the masses. What one presidential candidate said once were the despicables. They were just unworthy to be in the great class. And even though our Constitution says we don't give titles of nobility to our citizenry, we actually act like they have titles of nobility. I mean, look, we have an idiot president that was elected president because he was rich and not because he knew anything. And the people have this idea that just because you're rich, you know something. And that goes on throughout our society. So when you have classes coming from a certain class, judges coming from a certain class, you're going to have a certain class bias. And that got worse in the 70s under Nixon because they wanted to professionalize the prosecutor class, like the procurators under Rome. And they wanted to have professionalization, which meant that you didn't have a cross-section of the public in the function of prosecuting. You had certain people with certain beliefs, certain backgrounds, and certain social structure, and they became the prosecutors and the judges. And prosecutors, generally, that was the first career step in the way to a judgeship, and judges were recruited from the prosecutorial ranks. Part of that was because of the idea of retirement. And to save money, most states mandated that they chose judges from people that had already put some time in the state civil service so that the cost of the pension plans wouldn't be as much as they would be before. So for instance, when I started practicing, there wasn't any judge that had been a former prosecutor. They'd been in the business community, and they pretty much reflected the values, the views, etc. of the community. Well, when you have to have law by decree, you can't have that. Everybody has to get in lockstep with the dictator or the ruler or whatever they want to call him. And people that come up through the bureaucracy are much more likely to do that. So what we've got is career prosecutors, and the career prosecutors get indoctrinated to a certain way of thinking, mainly under the instruction of people that work under military or martial law or under Napoleonic Code, and that gets the structure we get today. So, for instance, when I started practicing, there's about 300,000 people locked up in the United States. Now there's close to 4 million. Now, I'm old, but not quite that old, and that's a geometrical expansion and not an arithmetic expansion. Why? Because we have a consensus and the safeguards have been abolished. I started right during the Vietnam period, right during the civil rights period. And I won a lot of trials and picked up a lot of enemies, of course. But I can remember one trial, and particularly here in Boulder, they caught a guy cold with a pound of marijuana. And this is about 68 or 69. And the cops kind of exaggerated a little bit, and I ordered to the jury that even though they were told to convict, they didn't have to, they were made to. And you want to send some student to prison for smoking a little dope or possessing a little dope, go ahead, if that's the kind of society you want. But you could see that the cop exaggerated and certain facts were altered or exaggerated. And that's the type of society we're going to get with that type of law enforcement. And if that's the type of society that you want, convict my client. But if you think the society deserves a little bit more than that, a little more honesty, a little more integrity, a little more truth, a little more compassion, then vote not guilty. And they went in there and voted not guilty. Well, the dumbass DA at that time thought, well, Boulder isn't going to convict any marijuana cases, which was absolute bullshit. They just didn't like the zealotry. The other thing I did at that time was a lot of draft cases. And the same thing, people avoiding the draft were getting convicted for that reason. Because even though the administration or some of the people in charge thought, well, there's a law, you can't avoid the draft, and if you break that law, we're going to prosecute you, it wasn't just. And that was one of the differences. And up until Nixon, the American common law had been just. So here's a couple of things that you need to know. When I taught this subject, I used Victor Hugo's book, Les Miserables, as a good, easy example of differentiation between common law and Napoleonic law. And here's a writer who was talking about that. I don't know whether he heard some of my lectures or not. I would like to think so, but I think it's quite possible he could have thought of it himself. But they're talking about nullification. And this was during the, prohibition thing, but I'll get back to that in a minute. I can't find this thing on. Benjamin Franklin, for instance, said that nullification is better than law, and ought to be the law, will always be the law whenever justice prevails. Thomas Jefferson said about the same thing. Hamilton said, a jury to make use of their own consciousness and understanding in judging of the lives, liberty, or estates of their fellow subjects have the right, beyond all dispute, to determine both the law and the facts. So, that's our tradition. But our tradition got changed somehow. And I've been spending decades trying to figure out why. But it's been used, the nullification has been used in Fugitive Slave Act and various other things, capital punishment. The Quakers used it. It was one of the big supports for the First Amendment, freedom of religion, which is what the Patriot movement says that was a reason for people to come to this country. And ironically, the Patriot movement pretty much doesn't really like the idea of jury nullification. And one of the really interesting things is we've got an attorney general here that talks about unified executive, which is totally contrary to all the things that the patriots that first came to this country were thinking or talking about. So here's a quote from Justice Stone in 46, for instance. If a jury feels that the statute involved in any criminal offense is unfair, or that it infringes upon the natural God-given unalienable rights guaranteed in the Constitution, then it is the duty to affirm that the offending statute is really no law at all, and that the violation of it is no crime, because no one is bound to obey an unjust law. So that was an interesting quote then, talking about what a jury's function is. So think about the logic of it. You get a group of legislators, and the group of legislators are supposed to make the laws. How do they make the laws? Well, first off, they hold a few hearings, but particularly nowadays, you can't get elected without selling your soul to the economic interests. And the economic interests want certain things, and they expect by spending all this money to get them. So you say, well, it's fair. The Congress or the state lawmakers are the spokesman or the representatives of the people. Well, if you think about it, that's complete and utter bullshit. It's not. They represent the interests of the ruling elite, of the financial people, through their lobbyists and people like that. People like me, solo practitioners, petty bourgeois merchants, ex-barbers, don't have any of that kind of power. I ran for district attorney once and lost by 221 votes, and it cost me $5,000. My opponent spent $120,000. I couldn't go up against that. I remember one article in the paper said that he had donated donated an ambulance to one of the cities here. And the press called me and said, what are you going to give? And I said, hell, I can't even afford to buy tires for one of those things. But that's one of the big differences. And there is this class difference and economic difference that people just aren't thinking about. And it's easy to say, well, it's a black thing or a brown thing or a green thing and not look at the economics. And my view is you can get all the black and brown people you want into various positions. And if they're from the ruling elite and view themselves as a ruling elite, it ain't gonna matter. So let's take a look at Les Miserables and Miserables and Victor Hugo. And I'm sorry I can't find this now. I had it before I started talking about it. And, oh, here we go. This one writer said, Victor Hugo highlighted the difference between justice and law. The jury's responsibility is to deliver justice, not to uphold the law. Judges in Maryland and Indiana are required by law to inform the jury of its right to nullification. Maryland Bill of Rights says, in the trial of all criminal cases, the jury shall be the judge of law as well as of fact. So that's sort of the history. That existed for several centuries. But you had a power grab, and you had the multinationalization, and you had a bunch of companies saying, why should we have local laws for all these countries that we're trading with? Let's get a uniform law so we can hire one lawyer rather than 100 to run things in this area. That was part of it. Part of it was the idea that people were breaking the law and getting away with something. No matter whether the law was just or not. So you had a bunch of people, for instance, saying the law is the law, and the law says you can't drink. So we're going to prosecute you if you drink. We're going to prosecute you if you possess liquor. We're going to prosecute you if you sell liquor. We're going to prosecute you if you have anything to do with liquor. Well, toward the end of Prohibition, none of the juries would convict. Well, that wasn't too good. Vietnam, we had the same problem. A lot of juries wouldn't convict what they called draft dodgers. And with the criminal case, you only need one juror out of 12 to hang a jury where they can't convict. The other thing is, I was in a judge's chambers once when the Bureau of Prisons warden in Colorado called and said, quit sending us these draft dodgers. They're college educated, they're bright, and they're organizing the prisoners here and causing problems for us. We can't handle them here. They're causing too much insurrection and change. Well, that was the other problem with the administration and their tough on draft dodgers thing. They were putting educated people in prison, and the educated people were organizing prisoners, and it was backfiring on them. So now we've got all this stuff for change. And we're going to change this, we're going to change that. We're going to defund the police. Probably none of that will matter until we really look at the structure. And all we've got in the legislators right now are all kinds of ways to put band-aids on a problem. But you've got to change the basic structure. You can't put a black ruling elite judge in to replace a white judge and expect a different result. You can't put a woman in, a country club woman, replace the woman with a country club male and expect a different result. You have to diversify the population, and that's one of the things that juries do. Juries are taken from various classes. They have different views, and they're almost advisory. They should be looked at as advisories to prosecutors and to the public at large. And as Victor Hugo says, the English courts aren't there to enforce laws, and the judges aren't there to enforce law, but they're there to enforce justice. And I maintain that justice has pretty much died in this country, and justice should be resolved. And justice is not making people obey with the crack of a whip or the threat of a gun or a rubber bullet or a taser, but it's doing what's fair and what advances the interests of society and not individuals. And I thank you for watching. Hope you watch again. Bye.